The next matter is 26-90103 Sachs Global, the emergency motion to lift stay.
Yes, good morning, Your Honor. Heather McIntyre on behalf of Nancy Getz, and with me is my associate, Aguila Lopez Castro, who will be leading the hearing.
Yep.
Good morning.
Good morning.
Good morning, Your Honor. Sorry about that.
Good morning.
Good morning, Your Honor. John Brennan from Wilkie Clark Gallagher on behalf of the debtors.
Okay.
Good morning, Your Honor. Good morning, Your Honor. Alejandra Mercer. Sorry. Go ahead. Thank you. Elena Gabreki and Morrison Forrester for the Official Committee of Unsecured Creditors.
Good morning.
Alejandra Garcia Castro for Safety National Casualty Corporation.
All right.
Good morning, Your Honor. Christopher Hoskins of Paul Weiss on behalf of the ad hoc group of gift lenders and bondholders.
Okay.
Good morning, Your Honor. David Kaufman from Lauderberg on behalf of Bank of America as KBL agent.
All right. All right, Mr. Castro, Lopez Castro.
Thank you, Your Honor. Yes, thank you, Your Honor. So we're here on Ms. Gates' emergency motion for relief from the automatic stay that was filed at docket number 1142. The debtors filed an objection to the lift stay motion at docket 1488, and the debtors insurer, Safety National, filed a joinder objection to the lift stay motion at 1538. Ms. Gates filed a response to the objections at 1768, and that was filed yesterday. Ms. Gates also filed a witness and exhibit list and supplemental witness and exhibit list relating to the matter at 1498 and 1763, which we respectfully request to move to enter the exhibits 1498-1 through 1498-6 and 1763-1 through 1763-4 into evidence.
1798 what? 1 through?
So it's going to be 1498-1 through 1498-6.
Right.
And then 1763-1 through 1763-4.
All right. Does anyone object to the admission of exhibits 1498-1 through 6 or 1763 1 through 4?
No objection.
All right. They'll be admitted.
Thank you, Your Honor. And unless the court has any specific questions they would like me to address beforehand, I'd like to proceed with a brief background of the matter and address the objections that were raised by the debtor and Safety National. Right.
I've reviewed everything, including your response that you filed yesterday or this morning. So I'm generally familiar. So you can go ahead and do it. I mean, let me just, in a situation like this, I'm going to give the debtor some time. So we can either continue this to a final hearing, or alternatively, we can just pick a date and then the stay will lift, after 60 days or whatever time, because I'm going to give the debtor some breathing room up front, at least on the preliminary hearing time. So, but go, I don't want to take the wind out of your sails, but go ahead. But that's going to be my inclination.
Thank you, Your Honor. Well, I'll proceed just to have it for the record.
Okay.
And then your determination, of course, once I'm done. So, Your Honor, the lift stay motion filed by Ms. Gates seeks to lift the automatic stay for the pending litigation matter solely to proceed against the insurance policies, at least as it relates to the debtors. And the three other defendants that are the underlying defendants in the matter, which is a personal injury matter that Ms. Gates suffered on the premise of the debtors, all have indemnity agreements with the debtors. So I think the biggest factor was the SIR retention that the debtors assert would be a detriment to the debtor's estate or the debtors if the litigation were to proceed. I think the urgency, although the trial has been canceled, that was set for April the 6th, I think the urgency still remains, at least for Ms. Gates to proceed, because one, she has a Massachusetts state right for a speedy trial, and given her age, she's 67 years old and lives alone with limited assistance and income. Is not going to, it's going to be more burdened, I believe, by the stay being in place than the debtors will be by the stay being lifted, especially considering since it's going to be simply this litigation at the moment, and we don't believe that lifting the stay in this instance will create a floodgate for other claimants to come in and try to do the same thing. And with regard to the detriment to the debtors, I think that with regard to the SIR, I think that the particular circumstances in the case should give freedom to Ms. Gates because the debtor can indemnify the other defendants with regard to the obligations under the SIR. I had a much longer script than that, but given Your Honor's position before I began, I mean, I think that at this point it would be up to the court to decide if they want to proceed with allowing Ms. Gates to proceed with litigation or giving us a little more time to maybe work out a stipulation with the debtors or at least give an automatic a date for the automatic stay to be lifted in this instance.
And Your Honor, Heather McIntyre, if I may, just briefly, I think the particular facts and circumstances here with 3 non-debtor defendants indemnifying the debtor here makes the idea that the debtor would ultimately be responsible for the SIR rather remote, and that coupled with the circumstances of this particular plaintiff, the fact that the litigation has been pending for 4 years, weigh heavily in favor of granting the stay. Having said that, if the court is willing to have that stay lift 60 days from today, that would be relief very welcome to the movement here if that is the court's decision, and we would welcome an order to that effect.
All right. Mr. Brennan?
Yes. Thank you, Your Honor. So, Your Honor, we would oppose the request to lift the stay, including, at a determinate date in the future, and would request to the opportunity to continue to a final hearing so that we can respond and oppose the motion. The circumstances here, Your Honor, where there is no dispute that there's the petition claim is subject to the automatic stay. There's no dispute that there's insurance coverage and that there's a self-insured pension that is not paid. Under these circumstances, for the reasons set forth in our papers, we believe the Fifth Circuit has been clear about what the law dictates here, which is, as Judge Isger explained in the iHeart Media case, summarizing the Fifth Circuit case from Edgeworth, that the controlling question is whether the litigation would place the financial burden solely on the insurer or implicate the debtor. And in that case, the outcome, which in the circumstances that are now here and distinguishable as these are from those in the Edgeworth Fifth Circuit case, the court found that the stay relief was not appropriate. We think the same result is dictated here. The premise of the motion, both the emergency nature of it and, for the most part, the notion that there was any burden imposed by the stay at all, was that the trial date had been scheduled. That's no longer the case, as the debtors, or as the movement rather, has acknowledged. The movement has raised some additional reasons why they think there's urgency. We understand that, and we're happy to respond to that and address that at a future hearing. But for now, we find ourselves in the same position that we stated in our objection, which is that we're between a plaintiff that wants to litigate this pre-petition claim against the debtor. The debtor is not the insurer. An insurer who has made clear that they are going to enforce this self-insured retention provision, and that if the insurer incurs any liability, any costs in defending this action, that it's going to be a liability that is going to come back to the debtor. And so we believe that relief from this stay would cause unnecessary burdens for the debtors. So that's our position still, and for that reason, we would oppose any order that lists the stay now or at any specified date in the future, and are happy to address this further at
John, if I may respond to that, I think that argument triggers what I mentioned in the motion. I mean, the difference with Edgewood to this matter is, one, each of this stay motion is fact intensive and on a case-by-case basis to be determined by Your Honor. And the difference in this instance is that in Edgewood, the court said that it was the debtor would be solely responsible. But here, that's not the case. The debtor can indemnify the three other non-debtor defendants and has other avenues as well via seeking contribution under Massachusetts law, or to the extent that, and also to the extent that the debtors are liable for the unpaid SIR. I think that the court in Sturgill said that that because the insurance policy is not an executory contract to be assumed or rejected, the policy term has ended and the insurance premiums are paid in full, which is more likely here since that's the basis of the litigation, underlying litigation, is that in the event that the debtors are liable for any obligation under the SIR, that would give Safety National a unsecured general claim against the debtors. And so that would be pulled in with the general unsecured claims in the bankruptcy to be determined on how it's going to be treated by the debtors in the proposed reorganization plan. So I think that's the difference in this circumstance than in what was brought in Edgewood.
If I could address that briefly, Your Honor.
Go ahead.
Thank you. So first, I just want to clarify that the holding in Edgeworth, as we understand it, and as the iHeartMedia case made clear, is not that lifting the stay is inappropriate if the debtor is solely responsible for the cost. It's actually that lifting the stay is appropriate if the insurer would be solely responsible. And so that's what we should be looking for here is when the movement is saying that they want to proceed solely against insurance proceeds, is that actually the case? Is that actually the effect that lifting the stay would have? And the court in iHeartMedia was clear that in that case where there was an unfunded deductible that could be subject to reimbursement, that wasn't the case. The financial burden wasn't going solely on the insurer. The other point that has been raised in the response to our objection is the citation to the Sturgill case, and which really stands for the notion that an insurer's obligations are not excused if the insured fails to pay a self-insured retention due to bankruptcy. We're not disputing that principle, and I don't want to speak for Safety National, who's on the line, but Safety National's joinder, as I read it, did not stake out the position that they were refusing to defend this case if they have to defend it. Their position, as I understand it, is that if Safety National is required to defend it and incurs expenses that are subject to the self-insured retention, that will cause the debtor to incur liabilities from to Safety National. And now, if there's a difference of viewpoint, it sounds like, between Safety National and the movement about what the nature of those liabilities would be and how and what Safety National's recourse would be. We won't speak to that and get into that, but again, I bring it back to we are stuck in the middle of this effectively and find ourselves between a plaintiff who's trying to collect and an insurer who is saying that we will bear some responsibility if that happens. And so it would be inconsistent for the automatic stay. With the automatic stay, we would contend for us to have to be thrust into that position, including to have to contend with Safety National's position, whatever it may be, if that arises. And then the last thing I would just address is the notion that was raised in the response to our objection. It was raised for the first time. So again, we would appreciate the opportunity to address this at a final hearing, that in the underlying case, there is indemnification among the various defendants that makes it unlikely that the debtors would owe anything ultimately. For one thing, that potentially goes to liability and not to the burden of the defense here, including the burden it was placed by distracting the debtors and their management team to have to defend it. But beyond that, those issues of indemnification among the various defendants are subject to cross-claim funds. So I just wanted to clarify, and again, we can address this at a final hearing, that it is not a circumstance, as I understand it, where one of the other defendants is actively paying the bill of debtors. This is something that would require litigation to hammer out those details. And so at this point, speculative to an extent, as I understand it, to suggest that the debtors wouldn't bear any risk by proceeding with this litigation.
All right, thank you. So here's what I'm going to do. I'm going to continue this to a final hearing on May 7th at 11:30. But again, this is a personal injury tort. It's going to have to be decided in Massachusetts. I'm not going to indefinitely allow the state to stop this case from going to trial. So I would encourage you all, you could find an accommodation, but I'm going to give the debtor some breathing room. But I'm also inclined, I'll listen to the evidence, but I'm inclined at some point to allow this to proceed so that it can be liquidated. So, but
if I would bring one point also, that the argument isn't that the debtors are facing no hardship. It's that the debtors, what they face is in lifting the stay is considerably outweighed by the hardship that Ms. Getz will face in maintaining the stay. So it's not that they don't face any hardship. And the other point with regard to that it would distract the debtors, I mean, I think the case in Lutheran is sorry, I'll have to go back and look at the case, but there was a case added that says that just attending to a litigation is not a distraction for the debtors. But I defer back to you, Your Honor, with regard to the matter.
All right. So again, we'll just continue this till May 7th at 11:30 and finish it. But I would encourage you all to talk because you understand where my feelings about this situation. All right. Let me call my next matter. Thank you.